Hello aspirants, welcome back to Vyara Learnings. So in our discussion on Indian polity, we had started with fundamental rights. In the topic of fundamental rights, these are the 6 concepts that we must study. That is, firstly we must know the meaning of right, and also we must understand the difference between right and privilege. And then we must understand the types of rights. That is, there are rights like legal rights, constitutional rights, statutory rights. Here we must know the difference between each right also. And the next thing is, we know the fundamental rights were derived from the US Constitution, that is the Bill of Rights of America. So we must understand about that. Next is, we must understand the importance of fundamental rights, why these rights are called as fundamental, and what is the significance of this fundamental rights has to be understood. Nextly, we must study the characteristics of fundamental rights. At times we say that fundamental rights are justiciable, and also we say that yes, fundamental rights can be amended, and we say that fundamental rights are not absolute. So we must understand the meaning of each of the characteristics of fundamental rights. Next, we must study the list of fundamental rights. That is, I said that there are 7 fundamental rights. There were 7 fundamental rights. Now, one fundamental rights was removed. So, at present, we have 6 fundamental rights. We must know the right which was removed, and we must know the Constitutional Amendment Act through which that right was removed. We had already covered all these details in our previous video lectures. So, please refer to the previous video lectures to understand all these concepts. Now here, as I said, see, part 3 of our constitution is from articles 12 to 35. Here, article 12 gives the definition of state, and article 13 is providing the definition for law, whereas articles 14 to 32 gives the list of fundamental rights. But the part 3 of the constitution is from article 12 to 35. So here the articles 33, 34 and 35 has to be studied, and we shall study these 3 articles now in this video lecture. So here we had already studied, right? That is in article 19 clause 1c, we had studied that there is a freedom to form associations, unions or the groups, correct? So to this freedom to form associations, there are restrictions to the uniform services. Uniform services in the sense it can be the police or army or the air force. So for these uniform services, the freedom to form associations can be restricted. Who can restrict it? That is, Parliament by passing a law can restrict the freedom to form the associations for this uniform services. That is what is article 33 is speaking about. That is, we know under article 19 clause 1 subclause c, there is a provision that there is a freedom to form associations, whereas this freedom to form associations is restricted to the uniform services, and this restrictions can be made by Parliament by passing the law. So that is what is article 33 is speaking about. Next we have is article 34. Yes, here article 34 is restricting the is speaking about the restrictions on fundamental rights itself. That is, the fundamental rights can be restricted when, that is, it can be restricted when the martial law is in force, and the restrictions can be, once again, it can be made by Parliament by law. So here one thing is simple, that is, whenever the constitution is not speaking about something, that is, if constitution is silent about it, it is just empowering the Parliament to make laws on it. That's it. So if the subject field is empty, that is, if the constitution is not giving the descriptions of that, then it is empowering Parliament to make laws. So here also, yes, there can be restrictions on fundamental rights when the martial law is in force, and for that restrictions the Parliament has to make laws. That is what is article 34 is speaking about. Then what is the meaning of martial law? Martial law is nothing but it is the military rule. That is, if the law and order of that place is controlled by the military, then it is called as military rule or the martial law. So when the martial law is in force, there can be restrictions on the fundamental rights that we enjoy. So this restrictions, what kind of restrictions can be made? All that has to be made by a law, and that law has to be passed by Parliament itself. So here, as I said, it is by Parliament. That is, whenever the constitution is silent, it is empowering the Parliament to make laws, right? So that is with respect to article 33 we had seen. That is when there is a restrictions to form the associations for that, and also under article 34 to restrict the fundamental rights when martial law is in force, all laws has to be made by Parliament. And also article 16 we had studied. That is, it is part of right to equality, correct? So in article 16, it is providing for it says that there shall be no discrimination when providing the public employment, correct? But this is not absolute because there are exceptions also. But on what grounds? That is on the grounds of residence, yes, reservations can be made with respect to the public employment. That is what is Article 16 Clause 3 is speaking about. So this clause, that is to make the reservations on the basis of residence, the constitution is empowering the parliament to make laws. Even if the employment is with respect to the state government also, parliament has to make laws to make reservations in the public employment on the basis of residence. That is what is Article 16 Clause 3 is speaking about. In Article 32, we had studied that Article 32 is all about right to the constitutional remedies. That is, if we feel that our fundamental rights are getting violated, then we can go to Supreme Court and ask to issue writs for the violation of fundamental rights, correct? So that is what is Article 32 all about. That is, Article 32 is providing for right to the constitutional remedies. So as I said, you can go to the Supreme Court directly and ask Supreme Court to issue writs. So it is Supreme Court. So what about the case of other courts then? So what Constitution is saying is, yes, Parliament can empower the other courts. Here once again Parliament is coming. So that is, Parliament can empower the other courts also to issue the writs for the enforcement of fundamental rights that is violated. That is what is Article 32 is providing for. For now, it is the Supreme Court which has got the authority to issue the writs for the violation of fundamental rights, whereas Parliament can empower the other courts also to issue the writs. That is what is Article 32 is telling. So here everything is, the power is for the Parliament. So that is the thing that is to be noted here. So that is what is Article 35 is speaking about. So as I said, Article 16 Clause 3, it says reservation can be provided in the public employment on the basis of residence. Article 32 Clause 3 says, yes, other courts can also be empowered to issue the writs. Article 33, it provides restrictions to form the associations by the uniformed services, and Article 34 is restricting the fundamental rights when martial law is enforced. So for all this, who is the body which can make the laws? That is the Parliament only. So all the laws with respect to all the above cases, that is Article 16 Clause 3. So there are 4 cases. The first is Article 60 Clause 3, and second is Article 32 Clause 3. Third is Article 33, and fourth we have is Article 34. For all these cases, only Parliament can only make the laws. That is the key which has to be remembered here. With this, we have completed part 3. That is, part 3 is from Articles 12 to 35. So with this, we have completed the part 3 of our Constitution. In the later video lectures, we shall study the later chapters in Indian polity. For more videos, keep watching Vyara Learnings, and also please subscribe, share Vyara Learnings. Thank you.